Hello, good morning, good afternoon, and good evening, depending on the time that you are listening to this video. This is Attorney Chato Alivas Quinto, and today I'm going to discuss complaint. Now, to make you appreciate the importance of a complaint, I would like to discuss it in a holistic way. So, i-discuss ko ngayon the significance of a complaint, the parts of a complaint, verification, and non-forum shopping certification, which are also parts of the complaint. So dun muna tayo sa importance of a complaint. The complaint is the most important pleading in litigation. Bakit? Because it initiates a case, which is why it is called an initiatory pleading. Moreover, it dictates the way a case will proceed, because the complaint shows you the following. In the title and caption of the complaint, you will see judicial region in which the court sits, the court which has jurisdiction over the case, venue where the case is filed, name of the plaintiff, name of the defendant, designation of either the cause of action or relief sought. In the first 2 or 3 paragraphs, you're going to see the name and address of the plaintiff, whether the plaintiff is an individual, a partnership, or a corporation, and the name and address of the defendant, and whether the defendant is an individual, a partnership, or a corporation. Now, why are these important? The names and addresses are important because in personal actions, the choice of venue depends on the place where the residence of the plaintiff is located or where the residence of the defendant is located at the option of the plaintiff. Now, if the case is filed in another place, there is improper venue, unless the parties have made a valid written stipulation on a different venue prior to the filing of the case. This is discussed in a different video regarding venue. Now, in the body of the complaint, you will see the allegations of facts through which the plaintiff seeks to establish his or her cause of action. The latter part of the body will state the evidence that plaintiff will submit. The body will end with a prayer or a statement of the reliefs sought. This will be followed by the lawyer's signature, which will be followed by a verification, and which in turn will be followed by a certification of non-forum shopping, which we will be discussing later in this video. Since the plaintiff, or really the plaintiff's lawyer, is the one who prepares the complaint, it is the plaintiff who decides who the parties will be, where the case will be filed, what the cause of action is, what evidence will be presented, and what reliefs are sought. So in this sense, the complaint is the most important pleading. Now let's talk about complaint and subject matter jurisdiction. When you draft a complaint, you should be careful to indicate the court which has the proper subject matter jurisdiction over your case. This is indicated in the caption of the complaint. You will indicate if the complaint is to be filed in the MTC or RTC based on the provisions of the law on subject matter jurisdiction. So, remember that your choice of subject matter jurisdiction must be correct, because if a case is filed in a court that has no subject matter jurisdiction, your case can be dismissed at any time during the proceedings, either upon motion of the defendant or by the court motu proprio. Lack of jurisdiction over the subject matter is one of the 4 grounds for dismissal that can be raised at any time. Because when the court renders a decision on a subject matter over which it has no jurisdiction, that decision is void. Although subject matter jurisdiction is conferred by law, it is determined by the allegations of the complaint. To reiterate, it is the complaint that determines subject matter jurisdiction based on its allegations. The answer does not do so. Now, I'd like to illustrate this concept more concretely. If the complaint is for unlawful detainer, the MTC has subject matter jurisdiction. An action for unlawful detainer can be filed by a landlord who leased out a piece of real property, but the lessee continued to stay despite the termination of the lease contracts. Suppose the lessee, as defendant, claims in his answer that he owns the real property in an attempt to prove that the case is not for unlawful detainer and that the issue involves ownership of the property. The defendant insists that the RTC, not MTC, has subject matter jurisdiction given the assessed value of the property. He now files a motion to dismiss for lack of subject matter jurisdiction. Is this going to prosper? The answer is no. The reason is that the allegations of the complaint, not the allegations of the answer, determine the subject matter jurisdiction. Okay? Now, let's proceed to the body of the complaint. The body of the complaint should contain the following. Number 1, statement of the names and circumstances of the parties. Number 2, the statement of the facts constituting the cause of action. Number 3, the legal basis for bringing this case. Number 4, the factual basis for bringing this case. And when we say factual basis, we're talking about the evidence. So, and then you also include in the body the witnesses, meaning the names of the witnesses, the summary of their testimonies, and you must attach their judicial affidavits to the complaint. Then you must also include a listing of the documentary evidence and the real evidence. Okay, and copies of these must also be attached to the complaint. Now, for details, you must refer to Rules 7 and 8 of the Rules of Court. So, isa-isahin natin tong i-unpack. Ano? Sabi natin na ilalagay nyo dapat statement of the names and circumstances of the parties. As mentioned earlier, this will appear in the first couple of paragraphs of the complaint. So, for the plaintiff, a simple allegation is as follows if the plaintiff is an individual. Quote, plaintiff is Filipino, of legal age, single, and residing at 54321 Macopa Street, Frutas Village, Sampaloc, Manila. Close quote. If the plaintiff is a corporation, here is a sample allegation. Plaintiff is a domestic corporation organized under Philippine laws with principal address at 54321 Macopa Street, Frutas Village, Sampaloc, Manila. Okay, so after that, so you have the allegations about the circumstances of the plaintiff, the name, the address, then you go to the allegations about the defendant. If he is an individual, it will be as follows. Defendant is Filipino, of legal age, and with residential address at 987 Calle 11, Blackjack Village, Sampaloc, Manila, where he may be served with summons and other processes of the Honorable Court. If the defendant is a corporation, the allegation would be defendant is a domestic corporation organized under Philippine laws with principal address at 987 Calle 11, Blackjack Village, Sampaloc, Manila, where it may be served with summons and other processes of the Honorable Court. Okay? So note, these allegations would enable anyone to determine if the complaint has been filed in the proper venue if it is a transitory action. Now, the next part is statement of the facts constituting the cause of action. So the next paragraphs should state the facts, okay, that the present cause of action of the plaintiff consists of. Now, again, let us go back to the elements of a cause of action. Make sure that in reciting the facts or in narrating the facts, you are able to show that each element is present. What are these? The plaintiff's right, that's the first element. The second element is the defendant's obligation. And the third element is the violation committed by the defendant resulting in damage or injury to the plaintiff. It is important that the factual basis of each element be stated in clear terms. Do not rely on implications. Dapat malinaw na nakasulat yung factual basis. Now, in preparing your complaint, the best way to present it generally is in chronological order. It would show a clear and logical story, starting with how plaintiff's right was acquired or recognized, what the defendant did to violate the right, what injury the plaintiff incurred because of the violation. The chronological order makes it easier for the judge and the parties to process the story. Naturally, the story should end with the effects of the violation, injury and damage, costs and expenses incurred by the plaintiff. And the natural consequence of this would be the relief sought. What remedies does the plaintiff seek to restore him as close as possible to his position before the violation? This will entail indemnity for damages or payment of a sum of money, interest, costs, and attorney's fees. Now let's go to the next part, which is statement of the legal basis. Under Rule 8, Section 1, It states, every pleading shall contain in a methodical and logical form a plain, concise, and direct statement of the ultimate facts, including the evidence on which the party pleading relies for his or her claim or defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof and their applicability to him or her shall be clearly and concisely stated. So based on this, you should state the legal basis of your claim. Now, after the legal basis, meaning the law and jurisprudence, you follow with a statement of the factual basis. So, pag sinabi nating factual basis, this is your documentary and real evidence. Remember that I have always been saying that every case deals with only two types of issues, legal and factual. Legal issues are resolved by a resort to the applicable laws. Factual issues are resolved by a study of the available evidence. Therefore, in your complaint, you are required to lay down the factual basis of your claim. Now, Rule 7, Section 6 requires you to include the following in your complaint. Names of witnesses who will be presented to prove a party's claim or defense, and then summary of the witnesses' intended testimonies, provided that the judicial affidavits of said witnesses shall be attached to the pleading and form an integral part thereof. Only witnesses whose judicial affidavits are attached to the pleading shall be presented by the parties during trial, except if a party presents meritorious reasons as basis for the admission of additional witnesses. No other witness or affidavit shall be heard or admitted by the court. Kaya dapat nakadisclose na lahat sa complaint pa lang. Pag hindi nyo sinamit yung judicial affidavit, hindi nyo na pwedeng i-present yung witness na yun. Except for meritorious reasons, which are exceptional in nature and discretionary upon the court. And then you must also give an enumeration of the documentary and object evidence in support of the allegations contained in the pleading and attach these copies of these or reproductions of these to your complaint. Now, this will be followed by the prayer, the lawyer's signature, verification, and certification of non-forum shopping. So, isa-isahin natin to. Doon muna tayo sa prayer. Ang tawag din dito, the reliefs sought. The prayer in the complaint tells the court what reliefs the plaintiff is seeking. The reliefs must be specific because these tell the court exactly what the plaintiff should prove by evidence. These also serve as the basis for computing the filing fee. Now, according to the Supreme Court, the court's grant of relief is limited only to what has been prayed for in the complaint or related thereto, supported by evidence, and covered by the party's cause of action. That is in a 2013 case entitled Leticia Diona versus Romeo A. Balangüe. Now, plaintiff may include a general prayer for such other reliefs as may be just and equitable in the circumstances. The Supreme Court said, certainly, a prayer for other just and equitable reliefs appearing on a complaint or pleading normally enables the court to award relief supported by the complaint or other pleadings, by the facts admitted at the trial, and by the evidence adduced by the parties, even if these reliefs are not specifically prayed for in the complaint. That is in the case of Ilusorio versus Ilusorio. That is why it is important that you will include that phrase at the end of your prayer, a prayer for such other reliefs as may be just and equitable in the premises. Now, after this, you follow with a lawyer's signature. And this is also very important kasi may mga ethical commitments ang signature ng isang abogado. And you find that in Rule 7, Section 3. So every pleading or other submissions to the court must be signed by the party or counsel representing him or her. What is the significance of the lawyer's signature? It is a certificate by him that he or she has read the pleading and document, that to the best of his knowledge or her knowledge, information, and belief formed after an inquiry reasonable under the circumstances. Number 1, it is not being presented for any improper purpose such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Number 2, The claims, defenses, and other legal contentions are warranted by existing law or jurisprudence or by a non-frivolous argument for extending, modifying, or reversing existing jurisprudence. Number 3, the factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after availment of the modes of discovery under these rules. And number 4, the denials of factual contentions are warranted on the evidence, or, if so specifically identified, are reasonably based on belief or lack of information. Now, if the court determines that this rule has been violated, it may impose an appropriate sanction or refer such violation to the proper office for disciplinary action. Ano yung proper office? For example, the Integrated Bar of the Philippines, okay? Or any disciplinary action on any attorney, law firm, or party that violated the rule, or is responsible for the violation. Absent exceptional circumstances, a law firm shall be held jointly and severally liable for a violation committed by its partner, associate, or employee. The sanction may include, but shall not be limited to, non-monetary directive or sanction, an order to pay a penalty in court, or if imposed on motion and warranted for effective deterrence, an order directing the payment to the movant of part or all of the reasonable attorney's fees and other expenses directly resulting from the violation, including attorney's fees for the filing of the motion for sanction. And this is important. The lawyer or law firm cannot pass on the monetary penalty to the client. Okay, important. Now, take note of the sanctions and disciplinary action that may be imposed upon the lawyer and the law firm for violations of these commitments. Note also that these violations may be committed not only by the lawyers, but also by non-lawyer employees of the firm. Lastly, if a monetary penalty is imposed on the lawyer or the law firm, they cannot pass this on to the client. Now, let's go to verification and certification of non-forum shopping. There are these are different parts of the pleading, yung verification at saka non-forum shopping certification. These are governed by separate sections of Rule 7, namely Sections 4 and 5. Kaya lang, in actual practice, often the lawyer combines these two. Okay? Now, the verification should be under oath. It is signed by the plaintiff or his or her representative. There are two situations when the representative may sign. One is when the plaintiff is not available, as when he is out of the country. The other is when the plaintiff is a juridical person, such as a partnership or a corporation. The authorization of the representative is proven by a special power of attorney or a secretary certificate, which should be attached to the complaint. Now, the signature of the plaintiff or representative also has certain commitments that are specified in Section 4 and which should be alleged in the verification itself. So, ano itong mga commitments na to? Letter A, the allegations are true and correct based on the signatory's personal knowledge or based on authentic documents. Letter B, the pleading is not filed to harass, cause unnecessary delay, or needlessly increase the cost of litigation. And letter C, the factual allegations therein have evidentiary support, or if specifically so identified, will likewise have evidentiary support after a reasonable opportunity for discovery. Now, the signature of the affiant shall further serve as a certification of the truthfulness of the allegations in the pleading. A pleading required to be verified that contains a verification based on information and belief, or upon knowledge, information, and belief, or lacks a proper verification, shall be treated as an unsigned pleading. Okay. Now, the significance of an oath, meaning the verification, is that if it turns out that the allegations are not true, the person who signed it can be held criminally liable for perjury. Perjury is penalized under Article 183 of the Revised Penal Code. Okay. Now, let's go to the certification of non-forum shopping. It is governed by Section 5, and this is what Section 5 states. The plaintiff or principal party shall certify under oath in the complaint or other initiatory pleading asserting a claim or relief, or in a sworn certification annexed thereto and simultaneously filed therewith, a. That he or she has not theretofore commenced any action or filed any claim involving the same issues in any court, tribunal, or quasi-judicial agency, and, to the best of his or her knowledge, no such other action or claim is pending therein. Letter B. If there is such other pending action or claim, a complete statement of the present status thereof. And letter C. If he or she should thereafter learn that the same or similar action or claim has been filed or is pending, he or she shall report that fact within 5 calendar days therefrom to the court wherein his or her aforesaid complaint or initiatory pleading has been filed. Now, the rules also provide the authorization of the affiant to act on behalf of a party, whether in the form of a secretary certificate or a special power of attorney, should be attached to the pleading. Failure to comply with the foregoing requirements shall not be curable by mere amendment of the complaint or other initiatory pleading, but shall be a cause for dismissal of the case without prejudice, unless otherwise provided upon motion and after hearing. Now, the next one is important. Also important. The submission of a false certification or non-compliance with any of the undertakings therein shall constitute indirect contempt of court without prejudice to the corresponding administrative and criminal actions. Ibig sabihin, there is forum shopping, pero sinabi niya there is no forum shopping. Now, that is a false certification. Okay? And then, the provision continues. If the acts of the party or his or her counsel clearly constitute willful and deliberate forum shopping, the same shall be a ground for summary dismissal with prejudice and shall constitute direct contempt as well as a cause for administrative sanctions. So, ganun ka-importante ang certification of non-forum shopping. We're gonna be ending here and I will be seeing you at the next video. To get more videos that will help you in your law studies and bar review, subscribe to my YouTube channel. And I'd like you to read my virtual textbook on civil procedure at www.profchato.com. Finally, I want to share with you my favorite Bible verse found in Micah chapter 6, verse 8. Do justice, love kindness, and walk humbly with God.